Hey folks, welcome back to the channel. Today's courtroom clash brings us a father fighting to lower his child support payments, claiming he's unemployed and doing his best to get by. But here's where it gets messy. The mother's lawyer drops receipts that show his termination wasn't a simple layoff, but a long list of disciplinary actions, from ignoring directions to even collapsing a pipe. He continuously pushes back, trying to spin it as a misunderstanding. But with the evidence laid out and excuses running thin, the tension builds as everyone's patience wears down. If you're here for a courtroom showdown where facts meets frustration, you've come to the right place. Let's get into it.
For the record, this matter is before the court on the defendant's objection to a referee recommendation denying defendant's motion to reduce child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff, Ashley Sumner. Ms. Sumner is present. In addition, defendant moving party Anthony Forrest is also present. Good morning, everyone.
Good morning, Amber.
The court has received the following order after de novo hearing this morning, which indicates that the referee recommend order be adopted but modified, namely the motion hearing for parenting time filed by Anthony before referee Hamrick, scheduled for December 19th, shall be rescheduled to January 23rd, 2025 at 1 p.m. And that will be before referee Hamrick, presumably.
Yes, sir.
But if the court adopts this, of course, it would deny the motion, the objection that the referee recommendation of child support of, I believe, what, $751, that would continue. Is that correct, Ms. Nemec, if the court understands this?
Yes.
Right. Mr. Forrest, do you understand the recommendation?
Yes, sir.
All right. Of course, it's alleged by Ms. Nemec that you were not just unemployed, but you were actually terminated from your employment with your employer. But
they have laid off due to lack of skills. So yes, you could call back.
Okay. Are you still on the work list with the union?
Yeah, on the out of work list. I'm still staying currently in contact. I don't know if I've put in my file the email with the guy who does that, but yes, I have been staying in contact with them every week and calling every couple of days. Yes, sir.
So it's important to make sure they have that contact and that you're calling her on a regular basis, Mr. Forrest. You need to get back to work because this obligation will pile up on you. In the meantime,
yes,
maybe over the season, look for some seasonal work until you get called back.
Yeah. I've put my application probably 15 to 20 times. I mean, on Indeed and a couple other places around here. Yes, sir.
Okay.
But, trying to get caught up on everything. I've made 2 payments so far, and I'm just yes. So.
Okay. All right, Ms. Nemec, is this recommendation agreed with your client this morning?
It is. Thank you.
Right. Mr. Forrest, do you understand the recommendation?
Yes, sir. Yes.
Okay. Of course, with the court adopts recommendation, that will, in essence, affirm the referee recommendation that your child support continue at $751 a month. And that to the hearing regarding parenting time, you filed a motion to modify parenting time. That will be rescheduled to January 23rd, 2025 at 1 p.m. before referee Hamrick. And do you have her Zoom ID number?
Yes, sir.
Great. Do you have any objection to the court adopting this recommendation?
What was that? I'm sorry.
Are you agreeable with the court adopting this recommendation this morning?
For the child support, sir?
Both.
For the parenting time, yes, I would like to talk to you a little bit on the child support, I guess.
Go ahead.
Just with this getting put into, on the record with me not working, as of that day, I was making that amount of money, a week or 2 weeks prior to this, 751 recommendation. And I'm just not working right now. I'm trying to get caught up on arrearages. I really need to get that paid down, because obviously nobody wants something like that over the top of their head. But I know we spoke about the insurance. I was carrying insurance on River. I guess it's not mandated, but I guess that's a little better for me. I'm just trying to. I'm not trying to evade paying child support whatsoever. Chris, as Ms. Nemec has said, but I'm just trying to get in a spot where I can balance my stuff to where I can make like arrearage payments and that are actually going to look, every month or whatever. It's going to make a difference. I'm just trying to get it knocked down either until I go to work or until something happens, I guess, Your Honor. I mean, $800 or $750 is unmanageable for me as of today, as of right now, in my current situation with my bills and everything like that. And I know everybody has bills, but I mean, trying to get more time with my daughter. I only see her obviously 5 hours a week. And
Are you collecting unemployment?
no, sir.
And did you apply and you were denied?
Yes, sir.
Okay, and denied because of the circumstances under which you were terminated, is that correct?
And the lack of how long I was working, sir. Yes. I want River to have everything. I want her to be taken care of. Like, obviously, Miss Sumner makes upwards of 80,000 a year, and I have made anywhere from 6,500 to 10 grand this year. I mean, it's hard for me right now.
Ms. Nemec, you've attached to your pleadings, it looks like a bank statement for the Chase Bank for Mr. Flores, and it suggests a deposit of $22,700 some.
Yes, which he also withdrew that same sum on the same day that this court ordered that he pay child support. In addition, Mr. Voorhees has income from a property that he recently sold. And as the court is already aware, there's been no change of circumstance at all since Mr. Voorhees, or since the last time we were here on this issue. The order was entered, I believe, September 17th. He lost his employment on September 12th. The employment he was not laid off. It was for cause. I've provided the court proof of that as well. And it honestly, Mr. Voorhees being a member of the union, he should be able to obtain substitute employment, but he has not.
Right. Sorry. They keep their seasonal employees, I guess, is what I could say. I'm kind of a newbie. And yes, that $22,000 was from an inherited building that I inherited off my father, and that money is to get used to buy a house closer to the river. She is correct, but I didn't take it out to evade paying child support, Your Honor. I actually took it out. I didn't know if having a savings account or like just was illegal to do, to take money out of my checking. I guess I don't really know. In this case, but I did use the proceeds. For an EMD, I guess you could call it, and to buy 2 enclosed trailers, because I do have all my dad's stuff from the shop that I needed to put in storage, I guess you could call it. So yes, I did take it out. I'm not trying to evade child support, so I don't know where Ms. Nemec is going with this, I guess. But I don't know if she's getting to where the arrearage is. I don't know where she's stating, but as of right now, yes, I have an inherited property that all the proceeds is going to a house down there once it finally gets sold. Yes, sir.
Okay, and of course, the court recognizes, as did the referee McKee, that inheritance is not considered income for child support purposes. But obviously, you were last before the court on September
17th, I believe, Your Honor.
September 17th, and you knew at that time that you had been terminated, but you didn't address that.
Who, me, Your Honor?
Yes, was that addressed
I,
on Ms. Nemick back in September
It
12th?
it was when we met with Miss Brower, Mr. Foris made it clear that he was no longer working. Our position was because he was terminated for cause that it's appropriate to impute income to him. He wasn't laid off for any reason, such as, attrition of the workforce. It has demonstrated that he has the capacity to earn at that dollar amount. He's done it repetitively over the course of his employment. There's no reason Mr. Forrest could not be employed right now.
um,
I
she'd asked
assume
me
they've taken reasonable efforts to do so. Obviously, the court recognized that at least Mr. Forrest did take some affirmative action. He filed the motion rather than just sit on his hands and let these mergers accrue. The court's not opposed to reviewing the support issue when we come back sometime. There's no future court date with this court. Ms. LaPrade, what suggestions do you have for somebody like Mr. Forrest? Should he file another motion to reduce support, say in February, if he's unable to secure employment at the same rate of $71,000 a year?
Your Honor,
Right,
we
I
had
did-
discussion at great length on this issue. Because he has shown the ability to earn that issue, we will continue to use that income until such time as he has new income. So I told him that once he has new income available, he should file a motion at that point to have it looked at based off that income. As Ms. Nemick stated, though, once the party shows an ability to earn, because he was terminated, they disagree on why he was terminated, but it was by his own doing. So we would always use that income until such time as he can prove a new income because he did show the ability to earn it.
Thank you, Ms. LaPrade. I'm glad that at least was discussed. You understand all that, Mr. Forrest?
What did you say, Your Honor? I'm sorry.
Do you understand all that? The court was as pleased that that was discussed this morning, and obviously it was. Ms. LaPrade has given you some direction in terms of once you seek out secure other employment, file that motion.
It was discussed. I was told I was terminated for a lack of experience. So in turn of as that lack of experience, they can say terminated or not. Then the means to that, to making that $36 an hour isn't there because I do not have the skill set to make that $36 an hour.
Your Honor, I provided the court with documentation received from his prior employer through a subpoena response that he was terminated not because he didn't have a skill set, but because he had multiple disciplinary issues verbally noted by his direct supervisor, B. Simon, including but not limited to ineffective operation of equipment, disregarding directions, making grading adjustments after specifically being told not to. His cause for termination was repeated disregard for directions, causing change in surface grade over prior workspace, drove equipment over said space, collapsing a pipe previously placed.
And Ms. Nemick, you talked to Mr. Simon on the phone, correct? You have no email.
I sent a subpoena for production of documents, and these are the documents that were produced. I did not speak to anyone on the phone.
Mr. Forrest, you mailed a copy of that along with the motions attached to the motion.
Yes, sir.
He's received
Okay,
it
so-
twice. He received it in response to the November motion as well.
All right.
But
So, yes.
I'm sorry.
Well, based on all of what's been,
He talked with the company over the phone. That's where I was asking about what I was asking.
right, the court's in receipt of a written document that's attached to the motion as Exhibit A, Mr. Forrest. And so based upon what Ms. Nemick has stated, what's been set forth in the pleadings, as well as the comments of Ms. LaPrade, indicating that the reason why, based on this recommendation, the court's going to adopt this recommendation. So child support will continue, that's $741 a month. And once you secure employment, file another motion to reduce support. But until then, we'll consider this rate. And your parent time hearing will be January 23rd at 1 p.m. before referee Hamrick. So you've been mailed a copy of this. I will conclude this hearing. You can zoom out, have a good rest of the day, and do find some other employment, Mr. Forrest. That should be your top priority.
Can I say something, please, sir?
Go ahead.
It's just it's stating here. I mean, Miss Nemick could have. It's stating just in the notes that the multiple disciplinary issues noted B. Simon. Where is B. Simon noting this at? I was told I was laid off for lack of skill, sir. There's no potential evidence here that says there was an email sent from this company saying I was laid off like this. So in my eyes, I was laid off, Your Honor. There is no probable cause in this Exhibit A to say I was even, because all I'm seeing is a timesheet, and I'm seeing notes that Miss Nemec wrote down herself, Your Honor.
I did
this-
not.
this-
That is not-
Photos too.
that is
Mr.
not
Flores?
writing.
Mr. Flores,
sir.
look at the document. The court satisfied with the documentation submitted. This was not prepared by Mr. Nemec. This was an email to you. And it says multiple disciplinary issues verbally noted by B. Simon, including but not limited to ineffective operation of equipment, disregarding directions,
Yes, sir.
making great adjustments after specifically told not to do so, cause for termination, repeated disregard for directions, causing change in surface grade over prior workspace. Also, you drove equipment over the space, collapsing a pipe previously placed, forcing a costly reemplacement. So the court satisfied there's sufficient documentation to show that you were terminated for cause. So that will conclude this matter.
And it
You
says.
contact
it
the
says-
attorney, Mr. Flores, or file another motion once you see your
He
employment.
said he did not talk to him. Sorry.
Court has been satisfied. That will conclude this matter. The court's going to adopt the recommendation, Mr. Flores. So you can contact an attorney if you disagree with this.
It's just not adding. I appreciate it, Your Honor. It's just, this is just not adding up. She said that they emailed the company, and then it says issues verbally noted by B. Simon. So which is it? I mean, I was told I was terminated for a lack of skill. So in that turn, me having that lack of skill, that lack of $36 an hour, I would just like this child support change until I either go back to work or until I get new employment. Because as me not having new employment right now, I can't physically manage to do $800 or $750, even $800 a month, and try to get a bit of the arrear just paid off. I mean, I have a $6,000 arrear hold over my head right now, and I'm just asking for a little modification. That's all I'm asking for, Your Honor.
All right, your position is noted. This document is very clear that you were terminated. You weren't just laid off, you were terminated because of repeated disregard for directions. So with that, once again, the court will adopt the recommendation. Bug the union, Mr. Forrest, because it's and you have the skill set to get in this line of work. So with that, court's gonna adopt the recommendation. I'll conclude this hearing. You can zoom out. Have a good rest of the day. Thank you, Ms. Nemec.
Thank you, Your Honor.
There's just no evidence here to where it's saying.
That hearing had it all. A father pleading like his life depended on it, a lawyer dropping receipts with laser precision, and a judge who'd clearly heard enough excuses for one day. When it comes to child support, sympathy simply doesn't cut it, especially when you're terminated for cause and still trying to spin it in a different way. So what do you think? Was the judge too firm, or did the father dig his own hole here? And honestly, if collapsing pipes is part of your work history, maybe it's time to rethink the whole "I'm doing my best" argument. Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.